the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the Legal Hour. Actus nemini facit injuria. The act of the law does no one wrong, but uphold justice. Hello viewers, welcome back to your favorite most legal show. This is the Legal Hour here on Freetown Television Network with Marrah. And the Legal Hour, this is our second episode, and I want to welcome you as the last time we had a wonderful show. This is a show that actually focusing towards the improvement of the legal concept, notions on even legal personalities, the common man and the nation's right. And the Legal Hour is a show that is looking keenly to see how best we can enhance the legal concepts of those that are supposed to know their rights and that they feel like as if they do not know, and that sometimes when the law acts as it's supposed to be acted, they feel as if their rights are violated. And we are here to educate the mass area. And part of our show, we have our discursive topic, we have our legal news, and you have the ALC, the all legal concepts. And for today's episode, it's gonna be wonderful. I think I'm gonna say it's gonna be legally delicious, of course, because I have with me the Fourah College Law Society President Mohammed, Wurrie, who will be my guest here today to discuss on the topic crime and punishments. Welcome to the Legal Hour.
Thank you very much for having me.
Yeah. Well, before we start with the discussion, this is Mohammed Wurrie, the president of the Law Society of the Fourah College. First, let's have our legal news, and for this episode, our legal news is actually focusing on the rumor about Brazilian, one of its most famous footballer, Ronaldinho, who used fake passport and now he's been jailed. Let's just take a look.
Brazilian football, I'm not saying soccer, legend Ronaldinho has been labelled stupid by his lawyer after being banged up for using a fake passport. Adolfo Marin insisted the former and forever smiling Barcelona and AC Milan star had no idea he was doing anything wrong by trying to enter Paraguay with a dodgy passport. His bizarre and brazen comment came during an interview with a Brazilian newspaper, saying, "The courts have not taken into account the fact that Ronaldinho didn't know he was committing a crime, because he didn't understand he had been given false documents. He is stupid." The 39-year-old samba star and tiki-taka legend, along with his brother Roberto, were hauled to court after being arrested at the Sheraton Hotel in Asuncion on Friday. While Ronaldinho's lawyer appeals a decision not to allow the star to be placed in house arrest, the first photos of him in prison appeared on social media, still sporting his trademark grin. And Blas Vieira, the head of the Paraguayan jail, told Reuters, "In broad terms, he is doing very well. I see he is in good spirits, just like you see him on television, always smiling." The footy star, known for his tricks on the pitch, along with his brother, are claiming they are the ones who were tricked. His lawyer has said Ronaldinho had been given his Paraguayan passport as a gift by a businessman, assumed it was an honorary type document of no real value, and gave it to an official without thinking when he reached Paraguay, because it was the first thing he got out of his bag. This Brazilian businessman, who is alleged to have handed over the passports, and two women believed to be the rightful owners of the travel documents, are now also in custody. Interestingly, Ronaldinho did actually have his Brazilian passport confiscated after he was convicted alongside his brother of building an illegal fishing platform on a lake in a conservation area. But Paraguayan prosecutors confirmed earlier this week that it had been returned to him. So why didn't he use his own passport when entering Paraguay? Twinned with his lawyer's comments about it being the first thing he laid his hands on, this situation is being greeted with a mixture of ridicule and disbelief. Or maybe he really is just stupid.
If you want more Tomo in your life, click the subscribe and bell button so you get notified.
Who has been termed stupid for using a fake passport, and now he's been jailed for 6 months imprisonment. Now back to our topic, which is the crime and punishment, and I have with me the Law Society president, I think it's Mohammed, Wurrie, and he's also a final here of the law department in Fourah College. Our topic is crime and punishment. So looking at the topic crime and punishment, or in other words, crime and wrong, what could you actually infer from that?
Well, first of all, thank you very much for the invitation, for having me here this evening. The topic, crime and punishment, or crime and wrong, is a very, very big topic. It's a matter of jurisprudence. Before I make my own submission, may I kindly state that as student of law, I am only making a comment on this particular topic because by virtue of jurisprudence, I do not hold the academic pedigree to form an opinion when it comes to issues of the law, because I'm still a student. But however, for purposes of the program, I will have to answer the question. Well, as I asserted earlier, the issue of crime, as I said, is a very jurisprudential or a relative term, because what is perceived as a crime by some people cannot be seen as a crime by other people. For example, now in Sierra Leone, if you talk about adultery, it's by virtue of our laws in Sierra Leone, it's one of the ways in which one can bring an action for divorce in a court of law. But if you talk about adultery in countries like Egypt and Saudi Arabia, who practice the Sharia law, for them it is a crime. So in other words, when we talk about crime, it's very difficult. It has no universal definition. One cannot discern actually what is a crime. However, Smith and Organ attempted to bring about these different schools of thought in defining the term crime. It started by bringing the people who perceive crime as a public wrong, people who see crime as anything that is against the general interest of society, what society perceived as crime. But the problem is that thing universal. For example, according to Carlton Allen in his book Legal Duties at page 223 to 233 to 234, he said crime is anything that is against the interest of the public, and it's something that cannot be left to the person that has been the person that has suffered from the crime or from the action being done by the actor, but it must be reduced by the state. So in other words, according to Carlton Allen and people who hold the same view, for them crime is anything against the public, which is a public wrong, and it is punishable by law. And who is supposed to punish you for that is the state. But the question is, if Allen and his disciples are saying crime is something that is punishable by law, that's something that is contrary or in contravention of the norms of society, then how can we define society in that context when society itself is a relative term? What we have here in Sierra Leone is not what we see in Germany or what we have in the United States of America. We have a complete, total different when we talk about culture, we talk about socio-economic perspectives. So looking in that point of view, we cannot accept that definition as jurists or jurisprudents will say, because that itself has some issues in itself in the definition. Also, there are people who perceive crime as something, as a procedural perspective. For example, people like Lord Atkins. I think Atkins once observed in the case of Propriety Article Trade Association Limited and the Attorney General of Canada. Is a case that was decided in 1931. Lord Atkins said, he said, crime cannot be discerned by intuition, but it can only be discerned by an action of the state, meaning a procedure of the state, meaning something can be done. It can be civil, it can be crime. For example, you're driving down the road and then you hit someone. That particular action in itself can be a crime, and it also can be a tortious liability. I mean, one can bring an action against you in a criminal procedure, and it can also bring an action against you in a civil procedure. For example, now, to kill someone is criminal, and also to deprive someone of his rights. I mean, do you know the law of tort is a law of obligation. It's as well tortious. So these are the complex issues. There are other schools of thought when it comes to crime and wrong. For example, people like Lord Devlin, they see crime as anything that is against morality. This is the Judeo-Christian Islamic perspective of the law, that anything that is against the commandment of the supreme being in the celestial world is considered to be a crime. And we also have people who have the practical view. These are people like Professor Adolphus Leonis Hart, who considered crime as anything that is practical, that is, for example, these are the sociological schools of thought. I remember Roscoe Pound quite vividly saying that the law must grow with the growth of society. So for Professor Hart and others, crime is anything that has been perceived as a public wrong, like the public school of thought, and also has been addressed by, for example, a competent institution that's supposed to address it and consider it to be a public wrong, like the parliament.
Let me just hold it there. I believe I've gotten lots of concepts about crime.
Yes.
But looking at the topic itself, it's so vast as crime wrong, and it's like you might tend to assume as if wrong is also a crime, and while other people have different perceptions about the word wrong, and while others have different perceptions about the word crime. But you have also deliberated on crime, and so far so good. I appreciate a lot. But now let's get to the meat of ourselves towards the context of the ordinary man in Sierra Leone. How do they perceive crime and how do they perceive wrong? And also, is there any distinction of crime and wrong, or they are just the same?
Well, the action in itself is what is perceived as the crime. The consequences of the action is what can be perceived as wrong.
So how do you,
that's the basic distinction.
So the action itself can be seen as the crime,
yes,
and while the consequences can be seen as the wrong.
That you've done something, and that thing that you've done is wrong. So the thing that you've done can be perceived as the crime, and the consequences of what you've done, the crime that you've done, can be perceived as the wrong, which can as well be called as punishment. And let me draw your attention to Kenny's, one of the top legal jurists, who once said that crime is anything punishable. He said that the question was asked, what is crime? Is anything punishable? What is punishable? Is anything that is crime? And Winfield criticized that particular assertion, saying that it leads to a vicious circle. Because if you ask what is crime, they will say crime is anything that is wrong. And what is wrong, they will tell you it's anything that has been done which can be perceived as a crime.
Okay. Now let's say if we are to accept the fact that the consequence of wrongful acts can be seen as a wrong, as you just said. Now what if in a scenario let's say I do something, let's say perhaps my girlfriend, alright, now she might have called me to pay a visit and I promised her that I'll be there, and I did not attend to such invitation, or I did not honor my promise. Now that could be seen as a wrongful act, and the consequence would be hurtful to her. Could that be termed as a crime?
That is
or
why.
wrong?
That is why when you asked me the question, and by the illustration you've given, when you asked me the question, I introduced you to so many schools.
Yeah, so many schools of thought.
Now, in that particular illustration, it will not amount to a crime because one, it is not against the general interest of society, is it? No, it is. You are only hurting one person, even though I'm coming.
You did say
yes.
The act you do could be seen as the crime, not so?
Yes.
But however, the consequence could be seen as the wrong.
Yes.
Now, limiting the crime itself, now let us come to the consequence. There is any act you do which is wrong, and then the consequence is very hurtful to either society or to any other person else. As long as it is hurtful, it could be seen as a wrong.
Well, that is why this particular school of thought, the procedural school of thought, has always held sway. The procedural school of thought, for them, it depends on the procedure that is taken. If that procedure, the one you did to your girlfriend, if it is taken in a criminal matter and it's acceptable by the court, by the court, and trying to link the two schools of thought to that of the practical test, if it is accepted by the court that what you've done is a crime and you've offended the general interest of society. That is why when we are introduced to the law, we are told that all criminal acts, you offend the state, you offend the general interest of the people, whereas civil acts, you offend an individual. So if that particular act can be perceived in a competent court of law as something that you offended the state or the peace of the state or the sanctity or sanity of the state, well, it can be considered a crime.
Well, you just mentioned that civil wrong, not so, and thus the word says crime and wrong, and thus we have actually realized that crime could be seen as a wrong that has been done towards society. And so I actually tended to make a reference towards a particular person, and I even introduced civil wrong.
Yes.
So that means wrong in itself, it's just something of inconsequence to a society or an individual.
Yes.
But if it affects society generally, then it's a crime. But if it affects an individual, it becomes a civil wrong.
Yes.
So now, what's the difference between civil wrong and
criminal wrong?
Yeah, a criminal wrong.
You've already answered the question by way of your premises and statement. You said if it affects the state, it is a crime. If it affects the individual, it is, even though some consequences of an individual can also amount to a crime. For example, you kill someone, you've affected the individual, you've deprived him of his rights to life, which is an inalienable right entrenched in section 16 of our constitution. Now, that in itself has what? Will amount. That is why the procedural school of thought will tell you, and the Lord Aitken, the Lord Deming, all these people will tell you that itself. Have you read the case of O.J. Simpson? You realize in the case of O.J. Simpson, a criminal action was brought against O.J. Simpson for offending the state by killing his girlfriend. And also a civil or a tortious action was brought against him by the family of the deceased. They brought an action against him for depriving them of their of the right to life of their daughter.
Okay.
So
and now we understood that when a wrong is being done to a society and it affects society negatively, it's going to be seen as a crime. Right. But when it's done towards an individual, it's a civil.
When it's perceived, I want you to qualify the statement. When it's passed, all of these things we are doing in human life.
Because this might just seen as the general differences, right? But I believe we might have other little characteristics that tend to give a contrast between the two.
The characteristics all now boils down to procedure. Probably, if we want to characterize them and try to differentiate them, it all boils down now to the procedure. For example, how it is approached to the court. The rules of evidence changes. For example, now for a criminal matter, the standard of proving evidence before the court is beyond reasonable doubt, whereas for civil procedure is a balance of probabilities, and also the burden the burden of proof in a criminal matter lies on the prosecution, whereas the burden of proof on in a criminal matter so in a civil matter in a civil action lies with the claimant. It depends also if the case has to go to appeal. It has to be what? The applicant or the appellant, you know. Yes, it all boils down now. The balance, which is all boils down.
So I say that you are legally oriented, and I quite appreciate such gesture. Well, let's take a look at the common people out here, the local who might not even read. How can they perceive that this particular act that I will be doing or that I'm doing is a wrong or is a crime for the ordinary man? Because for let's say perhaps your type or some of us that could read or perhaps can be taught to listen literally, we might be able to understand between the two. What about the ordinary man? How can I identify that such an act is a crime or it's a wrong?
Saint Thomas Aquinas, one of the best legal luminaries the world have ever seen, once observed in his book, the Summa Theologica, that in nature itself tells you what is right and what is wrong. For example, now, he compartmentalized the issue of law into four. He has what we call the eternal law. And the eternal law, according to him, the spider can build its web. The spider has no intelligence, but it can build its webs, and that web can be there to serve as a way of protection for the spider, and also as a way for the spider to have his food. So according to Aquinas, on his theory of eternal law, it means it is in you naturally to discern what is. Although Atkins debunked that in the Canada case by saying it cannot be discerned by intuition, but anything that is followed by what? A punishment. However, that's why I started by saying crime is relative. Now for us in Sierra Leone, if you kill someone intentionally, you kill someone intentionally, everybody will be pointing against you that you've committed a crime. This is natural, without even going to the element of murder, that you have to kill someone within a year and a day, the person you should have offended the president's peace, etc. But naturally now, at first instance, once you've killed someone, every member of society will be against you, saying that you've committed a crime. So for Aquinas, it is in you to discern that this what I'm doing is bad and this what I'm doing is good. You understand? So for the layman out there, he will know. It comes naturally. Even when you are driving, if you know you are committing a traffic offense, a criminal traffic offense, you tell it yourself.
So now you actually mean that as long as you can reason well, you'll be able to decide what is good and bad.
Yes, of course.
So then how can you perhaps explicate the presumption that ignorance of the law is no excuse? Which means you might be able to reason out what is bad and what is good, but some might say, well, actually I have no idea about whether it's a law, it's against general conduct, and then but as long as you do not know, it doesn't mean that you're supposed to be maybe not liable towards such a particular wrongful act.
Alright, thank you very much. The maxim ignorantia legis neminem excusat is for those who would want to use because in criminal law, generally two people are exempted from the law. Those who have justification of what they've done, and those who have excuse of what they've done. For example, a child, pursuant to section 70, pursuant to section 74 of the Child Rights Act of 2007, a child below the age of 14 years in Sierra Leone is excused by the criminal law. So if you allow a child below the age of 14 years to kill you, that child will be excused. Although the common law principle of juvenile delinquency, the common law principle of checking whether that child did that particular action, he was aware of the nature of what he was doing, those principles will be an exception. But however, the general rule is, as per section 74 of the Child Rights Act of 2007, if you allow a child to kill you, it go boss. Understand? And also for the purpose of insanity, a madman, you know, if that person is qualified as it was enshrined in the McNaughton rules of 1836, if that person is qualified under those elements in the McNaughton rules, and the court has proven it beyond reasonable doubt, the court has proven it, if it's the prosecution that raised that offense, the court has proven it beyond reasonable doubt. If it's the defense that raised the defense of insanity, they've proven it beyond in a balance of probability, and that thing has been proven in a competent court of law, that particular person, in pursuant to section 73(1) of the Criminal Procedure Act, that person will not be held culpable.
Alright viewers, this is Legal Hour here on Freetown Television Network, Channel 35. In today's episode, our topic is crime and wrong, and I've been having with me the president of the Law Society of the Fourah College, who is a finalist here of the Law Discipline, and I am your host, Bakarr. Let's just take a short break by running one of our ASC items, and today we're going to look at the Crown Court in England. Let's just take a look.
I am the judge, and it's my job to interpret and uphold the law. Other people present during a trial at the Crown Court are the prosecution barrister and the defence barrister, usually with solicitors behind them taking notes, and the jury. The defendant will sit in the dock and be present during the trial. It is at my discretion whether or not there is a public gallery. After the jury has been sworn in, I address them directly. I inform them that it is for them to decide if the evidence they are going to hear proves the defendant's guilt. I also inform them that it is their job to consider the evidence, not the law, and that I will guide them if necessary on points of law.
I am the next person to address the jury. I introduce myself and explain that I appear on behalf of the prosecution in this case, and my learned friend, who I name, appears on behalf of the defence. I then outline the prosecution case, explaining each offence and the evidence the jury will hear in proving this. I will state that it is the prosecution's responsibility to prove beyond any reasonable doubt that the defendant is guilty of the offence that they are before the court for. I will introduce the first prosecution witness. I will then ask a series of questions with regards to the evidence they have given in a statement to the police. This is known as examination in chief. Upon completion of this, the defence may ask the witness a series of questions. This is known as cross-examination. Upon completion of the cross-examination, I may be given the opportunity to ask a further series of questions to the witness. This is known as re-examination. I will continue to call witnesses until all the witnesses have been called to the stand. I will announce to the court that this is the case for the prosecution.
At this point in the case, I may make an application of no case to answer to the judge, stating that the prosecution has not raised sufficient evidence to prove that the defendant has committed the alleged offence. If he finds in favour of my application, he will instruct the jury to find the defendant not guilty, and then he will release the defendant. This is an acquittal. If the judge considers the prosecution has raised enough evidence, then I will continue with my case. As with the prosecution barrister, I will introduce the witnesses. However, at this time, they will be giving evidence for the defence. This will follow in the same procedure of examination in chief, cross-examination, and then re-examination. At the end, I will declare that was the case for the defence.
I then stand and give what is called my closing speech, where I outline the prosecution case and try to persuade the jury that the defendant is in fact guilty.
I then stand and give my closing speech, outlining the defence's case and trying to persuade the jury that the defendant is not guilty.
I will then sum up all the evidence. I will direct the jury on the legal issues and what the prosecution has to prove if they are to find the defendant guilty. I will give them the legal options available, reminding them that if they are not sure, they must find the defendant not guilty.
We then retire to make our decision. Once a decision has been reached, we return, and as foreperson of the jury, I announce the jury's verdict. If found not guilty, the defendant is released.
If the defendant is found guilty, I will make a statement in mitigation to the judge. The judge will take this statement into account before sentencing.
I thank the jury for the service that they have provided. If the defendant is found not guilty, I will release the jury from the court. If the defendant is found guilty, I will move to sentence him in a straightforward case. It is likely in that instance that the jury will remain in court. I may, however, postpone sentencing where other factors are to be considered. This can be particularly appropriate where there have been contentious issues or where the defendant's background is likely to have a significant impact on the sentence I pass.
Welcome back to the Legal Hour here on Freetown Television Network. You're 5 with me, Bakarr Marrah, and today our topic of discussion is crime and wrong. And I have with me Mohammed, the Law Society President of Fourah College. I think we actually gonna continue our discussion, and you were talking about child's responsibility when it comes to the criminal aspect. But I want us to give more keen attention to the ordinary man, because we are trying to at least get the concept for the ordinary man to be aware of such concepts. Now, if we have looked at crime in itself, how it affects society and how it threatens the stability of society, and we've also noticed about wrong, as I've just been learned about you, and I'm very much grateful. Now let's come to the most famous legal concept, the legal ideologies of the common people, like the police. They are too scared of the police. If anything happens, like the police. What do you think the police is actually playing when it comes to the issue of wrong and that of crime, or perhaps, in other words, the issue of civil wrong and criminal wrong towards the ordinary man?
Thank you very much. The police is a constitutional institution as mandated by the Constitution of Sierra Leone, Act number 6 of 1991. Of course, the primary objective of the police is to ensure the laws of the land are enforced, and also ensure that the lives and property of the citizens are protected and secured, as enshrined in the Constitution of Sierra Leone, Act number 6 of 1991.
So how does the police arrest? For example, there are times they just arrest people without their consent, and some feel deprived of their right, that they're not supposed to be arrested in the manner in which police usually arrest.
The power of arrest is encapsulated in section 11 and 13 of this Criminal Procedure Act of 1965, which means even a civilian, this is what people actually get wrong, even I, Mohammed, I can arrest. If I have seen that you've committed something that is against the peace of or the health or safety of the state, I am obliged to arrest you and bring you to the police. The only right I do not have to do that is to detain you, which is the sole right for the Sierra Leone police as encapsulated in the Criminal Procedure Act. So when it comes to arrest, in fact, there is a common saying that the police have over 100 rights over the civilians. Well, that itself, that is the common idea for the common man, because the police are empowered by law to ensure that the laws of this country are enforced. Because if we don't have the police to enforce the law, then what is the essence of the law? when the law is there to ensure society doesn't crumble. For we all know, we are told by Socrates that without the law, society crumbles. So we need institutions like the police, we need institutions like the courts to ensure the laws of this country, as they are enshrined in our books, are protected, and not only protected, are enforced and adhered to.
And now you just given one person the word enforcement, okay?
Yes.
So looking at criminal wrong, a lot of civil wrong, how can they be enforced? Is that the same way?
Yeah, but criminal is a compulsory enforcement, as it is in subsection. I stand to be guided. Subsection 4 of section 120 of the Constitution. Subsection 8, sorry, of section 120 of the Constitution of Sierra Leone. The court, the Sierra Leone judiciary, the court has the mandate to enforce the laws of Sierra Leone. Well, for civil rights, it is up to you, the individual that has been affected, to bring an action against your offender. For example, now, if one has committed the thought of nuisance, or let's say the thought of defamation, it is you who that particular action of that individual has affected. It is you. It is your sole right to bring an action against that person. You know, no one can force you to be. Even in the law of contract, what we are told in the law of contract, the law will only enforce that which has been bargained by the two parties. You understand? Or even though there are times when the law will come in and impute some certain terms for sake of peace, as the court is an arbiter of justice for sake of justice. But the court will not bring an action in themselves against you, against someone who claimed to have been whose right has been violated by way of tortious or a breach of contract.
And also in certain circumstances when the police are arresting, or the police is arresting somebody, that person always might presume, or in fact, now we have this here say this famous statement notion that when you used to say, where is your warrant? Do you have a warrant? And most of these common people don't even know what is a warrant. So can you tell us what is a warrant and how can it be identified?
I've told you that the Criminal Procedure Act makes right for even civilians to arrest you if they have the power to do that. Having the power, the physical power to do that, to hold you and take you to the police. The police need not come show you that I am the police. That's why the police has uniform. They have their ID cards. You know, they will come and they will show you, oh, you've committed this and that, and you are hereby and they will read to you the judge's rule. You are hereby arrested for so and so and so, and whatever you say or do might be used against you. Have the right to remain silent. Whatever you say or do might be used against you in a competent court of law. So that is it. The thing about the law is very just, and for purposes of the criminal law, the accused is presumed innocent at the point of arrest. At the point of arrest, the accused at that particular point in time is presumed innocent, and this is a constitutional right. It is entrenched in subsection 4 of section 23 of the Constitution of Sierra Leone. You are presumed innocent until you are proven guilty, and it is also a common law principle pursuant to the case of Ulmuntin and DPP, as Lord Sankey said. The accused is innocent. This is the flip side of the French law. In the French law, the accused is guilty. It is the right of the accused to go to the court and prove himself innocent. Okay. But for English law, you are innocent until otherwise is proven. So it is on the burden of the prosecution to go now to the court and try to prove their case beyond reasonable doubt. That is as a result of Mohammed Marrah's action that led to the consequence of what happened. Then you will be held culpable.
Hi viewers, this is Legal Hour here on Freetown Television Network, 35 with me, Bakarr Marrah, and time is now against our favor, so we are about to go down to this edition for next week. But however, before we cut down, can you just give your last statement on the topic crime and wrong?
Well, I will, by my capacity as the president of the Law Society, Freetown College, University of Sierra Leone, I want to use this opportunity to appeal to viewers and listeners down there to adhere to the laws of the land, because the criminal law spread its tentacles to catch whosoever is in contravention of the peace of the society, whosoever is in contravention of the safety, whosoever is in contravention of the health of society. Therefore, I enjoined one and all to be peaceful citizens, to be mindful of the laws. Remember, ignorantia legis nominem excusat. Ignorance of the law is of no excuse. So you will not come to the court of law and say, no, that will never hold sway. You should always guide yourself against committing a crime. For even that itself is immoral and it is against the spiritual books.
Thank you very much, and it's been an honor to have in my studio, and I also hope to have in my subsequent programs, just like you articulated well. You actually educated the mass out there about crime, about wrong, their differences, characteristics, enforcement. I believe most have been educated by your articulation earlier. Well, this is how we come to the end of today's edition. We really don't want to go. We have much to say, but time is against us. But just keep going to us, Legal Hour, and you have more in box to be revealed to you, to learn about the legality within the legal system of our country. But so far, so good, we have to go. So Tata, and have been your host, Bakarr Marrah. One of the most famous Latin legal presumptions of law is ignorantia legis nominem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you and you must know the law. Thus we bring you the Legal Hour. Actus nemini facit injuria. The act of the law does no one wrong, but uphold justice. One of the most famous Latin